We're picking up in 1985 in relation to England and the records retention guidance. 1985, further guidance was published stating that the minimum period for retention of records was extended to 8 years after the conclusion of treatment or the death of the patient, but in relation to obstetric records, it was 25 years. Moving forwards to 1999, the Department of Health published For the Record, Managing Records in NHS Trusts and Health Authorities. It's a health service circular. If we could put that up on the screen, RLIT 301726, please. And then if we turn on to page 3 from that cover sheet, we see summary, and it reminds those reading this health service circular that the primary function of the circular is to improve the management of NHS records in health authorities and NHS trusts. The circular sets out the legal obligations for all NHS bodies to keep proper records, explains the actions needed from chief executives and other managers to fulfil these obligations, provides guidelines on good practice, explains the requirements to select records for permanent preservation, lists suggested minimum periods for retention of NHS records, and indicates where further information may be found. If we then turn to page 4, it gives a helpful summary of the importance of sound records management practices in the NHS. Records management is most effective when it commands commitment from senior managers and is regarded as a professional activity requiring specific expertise. Records are a valuable resource because of the information they contain. That information is only usable if it's correctly recorded in the first place, is regularly updated, and is easily accessible when it is needed. Information is essential to the delivery of high-quality, evidence-based healthcare on a day-to-day basis, and an effective records management service ensures that such information is properly managed and is available to support patient care and continuity of care, to support day-to-day business which underpins delivery of care, to support evidence-based clinical practice, to support sound administrative and managerial decision-making as part of the knowledge base for NHS services, to meet legal requirements, including requests from patients under access to health records legislation, to assist medical and other audits, to support improvements in clinical effectiveness through research, and whenever and wherever there's a justified need for information and in whatever media it is required. If we turn then on to page 39, we pick up the retention and disposal schedule, and it indicates that the retention periods which are listed below reflect minimum requirements of clinical need. Personal health records may be required as evidence in legal actions. The minimum retention periods take account of this requirement. It's not necessary to keep every piece of paper received in connection with patients. NHS trusts and health authorities should determine in consultation with their health professionals which elements should be considered as a permanent part of the record and which should be transient and discarded as their value ceases. Going down through the table, we see that there is, if we can just zoom out please, Lawrence, we can see on the left-hand side children and young people with the period until the patient's 25th birthday, or 26th if the young person was 17 at conclusion of treatment, or 8 years after patient's death if death occurred before 18th birthday. Donor records 11 years post-transplantation. Maternity, all obstetric and midwifery records, including those of episodes of maternity care that end in stillbirth or where the child later dies, 25 years. Then over the page, oncology, 8 years after conclusion of treatment, especially when surgery only involved. Then there is a recommendation to consider a document issued by the Royal College of Radiologists dealing with patients who've been given chemotherapy and radiotherapy. And then general, 8 years after conclusion of treatment. A new code of practice called Records Management was published in 2006, and it was updated in 2016. We don't need to put it up, but for the transcript, the references are RLIT 301712 and DHSC 5001727. That new code provided that GP records were to be kept for 10 years after a patient died or after the patient had permanently left the country. Maternity records were to be retained for 25 years. Hospital records were to be kept for 8 years, with some exceptions such as clinical trials. In relation to children's records, it provides that documents should be retained until the patient's 25th birthday or 26th if the young person was 17 at conclusion of treatment or 8 years after death. But it also added, if the illness or death could have potential relevance to adult conditions or have genetic implications for the family of the deceased, the advice of clinicians should be sought as to whether to retain the records for a longer period. For the records of those diagnosed with Creutzfeldt-Jakob disease, their records should be retained for 30 years from diagnosis, including for deceased patients, and the new code indicated that oncology records should be retained for 30 years. The current NHS Code of Practice is the Records Management Code of Practice for Health and Social Care 2021. This is at RLIT 301284. Somewhat unhelpfully, so I'm afraid my version is in A3 version, so I'm hoping that my internal page referencing will work. We can see that this is August 2021, and could we turn to internal page 49, which I think is about page 90 on the electronic copy. 90. Could we try page 49 then? Wonderful. No. I'm sorry, sir. Just give me a moment. Do you want to try page 24? One more page on, and we have it. We are looking at the Appendix 2 to the 2021 code, which sets out the retention schedule. And we see, again, a table setting out the minimum periods of retention. Adult health records, not covered by any other section in this schedule, is a retention period of 8 years. If we go over the page, we have children's records, including midwifery and health visiting and school nursing, up to the 25th or 26th birthday, repeating the provisions we've looked at before. And then on the other side of the page, GP patient records for deceased patients is 10 years. Over the page, GP patient records for living patients, continual retention. And then over the page again, on the bottom right, we have obstetrics, maternity, antenatal and postnatal records, 25 years. And there is a note here for record keeping purposes. These are considered to be as much the child's record as the parent, so the longer retention period should be considered. Then over the page, we have on the left the cancer/oncology records, 30 years or 8 years after death. And then the other side of the page, Creutzfeldt-Jakob disease at 30 years or 10 years after death. And then this at the bottom of the page, long-term illness or illness that may recur, 20 years or 10 years after death. And the notes indicate necessary for continuation of clinical care. The primary record of the illness and course of treatment must be kept where the illness may reoccur or it's a lifelong condition, such as diabetes, arthritis, or chronic obstructive pulmonary disease. Thank you, Lawrence. So that brings us up to 2021 in England, and that can come down. And so I will move then to consider the Welsh legislative framework. Before the Government of Wales Act 2006 came into force, the situation in Wales was much the same as in England. So we see that at the same time as the DHSS issued its circular in 1980, the Welsh office issued a circular in the same terms, WBC 89. Similarly, in 2000, a circular was issued in Wales entitled For the Record, Managing Records in NHS Trusts and Health Authorities. And if we can look at that, RLIT 301725, please. We can see the front page showing that it's a Welsh Health Circular, and if we turn to page 3, we see a summary setting out the function of the circular, largely reflecting what we looked at in relation to England, that the circular sets out the legal obligations for all NHS bodies to keep proper records, explains the actions needed, provides guidelines on good practice, explains the requirements to select records for permanent preservation, and lists suggested minimum periods. And if we turn then to page 42, we see the schedule in relation to retention of records, and it's the same as that we looked at in relation to England. That can come down now, thank you. Section 148(1)(e) of the Government of Wales Act 2006 was enacted, and because of that provision, the Public Records Act continues to apply to the records of health service hospitals in Wales. The current position in Wales is set out in the Records Management Code of Practice for Health and Social Care 2022, a guide to the management of health and social care records. That's at RLIT 301718, please. Sorry, sir, my sticky notes just dropped out, and if you can just give me one moment. What we see here again is the provisions introducing the guide. If we turn to page 3. Setting out that it's relevant for all organisations working within or under contract to the NHS, and it refers to a series of appendices, including Appendix 2, which is a retention schedule for different types of records. And if we turn on to page 33, please. We pick up the retention schedule, which is, as per England, adult health records, 8 years, children's records, up to 25th or 26th birthday. It's the 26th if the patient was 17 when treatment was ended. And if we turn the page, we have the same provisions at the bottom of this page in relation to GP patient records for deceased patients, 10 years. Over the page, GP patient records for living patients, continual retention. And then on to page 37. We have the same provisions in relation to obstetrics, cancer and oncology, and Creutzfeldt-Jakob disease. And over the page, we have the same provisions in relation to long-term illness 20 years or 10 years after death. And if we turn on to page 41, we have a note in relation to the blood bank register, 30 years minimum, and in the notes it flags the ongoing this inquiry. The circular that accompanies this code, RLIT 301724, we don't need to bring it up, makes it clear that the code is based on the English circular and they are intended to operate together. Could we take that down now? We move then on to the position in Scotland. In 1937, the Public Records Scotland Act was passed. Section 12 of that Act provided that regulations could be made regarding the disposal by destruction of records which are of insufficient value to justify their preservation. In 1940, regulations were passed which appeared to have required the Lord Justice General, the Lord President and the Secretary of State to produce schedules of those documents considered to be of insufficient value to be retained by the Keeper of the Records of Scotland. The inquiry has identified one such schedule from June 1958. The reference is PRSE 40552, please. We see the very first paragraph that the schedule accompanying this memorandum authorises the destruction of various types of hospital records after certain specified periods. Then if we turn to page 9, we pick up that schedule. Point 24, medical records and allied documents in hospitals. Thank you. Medical records and allied documents in hospitals other than mental hospitals and mental deficiency institutions. Medical records including clinical notes, and we see within that there is also reference to blood transfusion records, operation books, casualty notes and day and night nursing report books, with the period after which documents may be destroyed set at 6 years after the conclusion of the patient's treatment at the hospital, provided that where the patient dies in hospital, the records may be destroyed 3 years after death. Ancillary records 3 years after the conclusion of the patient's treatment at the hospital. And then this in relation to 4-hourly temperature charts, fluid intake or output charts, or other similar ephemeral records, provided they reveal no abnormal conditions and that no notes are written on them, upon discharge of the patient, provided the patient is discharged without incident. This guidance, sorry, sir. We then pick up the next piece of guidance in the 1st of December 1993 with the document from the Scottish Office, Guidance for the Retention and Destruction of Health Records, SCGV 5038_042. We see the date on the top right, and in paragraph 6 towards the bottom, health records are defined. Health records for these purposes are those records which relate to the physical or mental health of an identifiable individual, which have been made by or on the advice of a health professional in connection with the care and treatment of that person or in connection with the organisation of that care. They include records contained in non-paper media, including microfilm, computer files, slides and specimens. If we then turn the page, there is some notes explaining recommended minimum retention periods, and then under the heading General Hospital and Community Health Service Health Records, it says this: there will be no change in the present minimum retention period of 6 years following the date of the last recorded entry or 3 years after death. All records must be kept in the original form for at least the first 3 years of the period, but may be microfilmed or transferred to other media thereafter and held in that form for the remainder of the period. We then have the heading Children's and Young Adults Health Records. There's discussion about time limits in litigation. Then we turn over and pick up paragraph 7. In the circumstances, to allow a sufficient period for any legal action to be initiated, the general minimum retention period for children and young adults has been changed to require records to be retained until the individual reaches the age of 25 years or 3 years after death if this is earlier. There is then the heading Obstetric Records. Associated with the records of children and young adults is the need to retain a mother's obstetric records. These should be retained for 25 years after the birth of the child, including stillbirth. Then if we go over the page, we have the headings dealing with GP records. There will be no change in the retention period for GP records held by health boards where the patient has died. This will remain at 3 years after death. Where individuals leave the country temporarily and have expressed an intention to return, the records should be retained for 6 years or such reasonable longer period as may be agreed with the GP or board and the person concerned. There's then addressing the question of children and young adults. And then we have the heading in relation to cancer patients. There is a need to maintain on a long-term basis records which are kept on patients undergoing radiation therapy and chemotherapy. These records are required not only during the lifetime of the patient, but also after death in order to allow an adequate and detailed audit of treatment to be undertaken. Accordingly, all records, including written records and radiographs of patients treated for cancer, should be retained for the lifetime of the patient and 3 years after death. There is then a heading dealing with patients with genetic disorders. And at the very bottom of that page, in the circumstances, they've set out the particular issues around genetic advice. In the circumstances, it's for provider units, including NHS trusts, on the advice of the consultants in charge, to consider the retention of records or parts of them in respect of patients and their families with disorders which may be genetic beyond the minimum period of 6 years as required for health records generally. And then over the page under the heading Retention of Records for Clinical Trials, there is reference to the EC Directive on Good Clinical Practice for Investigators, which was implemented in July 1991 and recommended that data should be retained for the maximum period of time permitted by the hospital, but not less than 15 years. The responsibility for retention of records for clinical trials is placed by the directive on the investigator. In 2006, the 1958 Guidance on Administrative Records was updated to take account of legislative changes, including the Freedom of Information Scotland Act 2002 and the Data Protection Act 1988. This made it clear that for personal health records, the 1993 guidance would continue to apply, albeit further guidance on this matter was to be forthcoming by the end of 2006. But that new guidance did not in fact materialise until 2008, when the Scottish Government published the Scottish Government Records Management, Health and Social Care Code of Practice. And if we can turn to that, RLIT 301146, and we can go to page 74. The scope of the schedule is addressed. This annex sets out the minimum periods for which the various personal health records created within the NHS or by predecessor bodies should be retained in line with Principle 5 of the Data Protection Act, either due to their ongoing administrative value or as a result of statutory requirement. It also provides guidance on dealing with records which have ongoing research or historical value and should be selected for permanent preservation as archives and transferred to an appropriate archive. If we then turn the page, we pick up the heading Retention Periods. Each organisation must produce its own retention schedule, specifying the locally agreed retention periods in the light of its own internal requirements. Organisations must not apply to any records a shorter retention period than the minimum set out in this schedule, but there may be circumstances in which they need to apply a longer retention period. And if we then turn to page 78, we pick up that minimum retention period. For adults, it is 6 years after the date of the last entry or 3 years after death if earlier. All types of records relating to children or young people retain until the patient's 25th birthday or 26th if the young person was 17 at the conclusion of treatment, or 3 years after death. If the illness or death could have potential relevance to adult conditions or have genetic implications, the advice of clinicians should be sought as to whether to retain for a longer period. Then if we carry on to page 81, page 82, I should say. We pick up GP records retained for the lifetime of the patient and for 3 years after their death. Page 85. Oncology, 30 years. The code was updated in March 2010 and January 2012, but the current code of practice is the 2020 version. We find that at RLIT 301150, please. And if we turn to page 58, we see adult health records the same as before at the bottom of the page. Children's health records are also the same, and they remain the same as do the categories I noted from the 2008 code. We can take that down. Thank you. We move then to Northern Ireland. In 1962, the Northern Ireland Hospital Authority Circular, HMC 75/62, came into force. And if we could turn to WITN 3449019, please, and it's page 3. The writing isn't very clear, I'm afraid, but in paragraph 1, it says the lists contained in appendices A and B shall be observed as the guide for selection and disposal of hospital service records, and we see the same wording as we did in relation to England. Appendix A lists classes which shall not be destroyed at all. Appendix B lists those which may be destroyed. Then we turn to page 5. This deals with classes of documents which are not to be destroyed, and at number 10 we see summaries of clinical notes taken, front sheets and registrar's books, etc. And if we turn to page 9, we pick up towards the middle of the page, Part 4, Medical, and we have much the same as the English circular. Medical records, including blood transfusion records and things like temperature charts. It's 6 years after the conclusion of treatment, where the patient dies in hospital, 3 years after death. Operation books, 6 years from the date of the last entry. Casualty notes, the same. Day and night nursing report books, 6 years from the date of the last entry. This circular was amended in 1983 by the DHS SPS circular, itself given the initials HSS OS 1/83. Our URN is WITN 3449020. And if we turn to page 3, we have minimum periods of retention for personal health records. We have the same wording, largely the same wording as in the English circular about the need to consider retention periods in light of legal actions and time limits. The circular proposes new minimum retention periods, which the department believes are likely to prove acceptable to the courts. And we then see that there is special considerations applying to records relating to children, young people and mentally disordered people. In most cases, a person or his representative might be expected to know whether he has a cause of action within 5 years of the alleged negligence, from which time the limitation period should be taken to run. And so we see obstetric records, the minimum retention period is 25 years, children and young people until the 25th birthday, or 8 years after the last entry if longer. Those records need only be retained for a minimum of 8 years after the death of a patient, or in the case of obstetric records, death of the child. Relation to all other personal health records, 8 years after the conclusion of treatment. And then if we turn the page, we have this in relation to microfilming of records. Paragraph 8 of Circular HMC 7562 recommended that microfilming should not be used as a method of reducing the bulk of documents held, and that if documents have been selected for permanent preservation, the original documents must be preserved, and it was not permissible to preserve microfilm copies in their place. Legal opinion now indicates that by virtue of the provisions of the Civil Evidence Act, Northern Ireland 1971, it is acceptable to substitute microfilm copies for the original documents within the period for which those documents must legally be retained. This Act amended the law of evidence in relation to civil proceedings, and it goes through how it's done that, and that the provisions deal with microfilm. Paragraph 9. In view of this change and the extension of minimum retention periods for personal health records recommended in this circular, together with the increased pressure on storage space to which this will inevitably lead, boards who are not already using it may wish to consider the merits of microfilming as a method of reducing the bulk of documents held. In 1996, the HSSE 3/96 retention of personal health records came into force. This set out new guidance on destruction of confidential health records not held by the Central Services Authority. Records of children and young people should be retained until they turn 25 or for 8 years after the last entry or their death, whichever was longer. Maternity records should be kept for 25 years. All other records should be kept for 8 years after the last entry. In 2004, Good Management, Good Records was published. This set out the minimum periods for the retention of health and personal social services records of all types, except for GP medical records. It indicated which records were likely to be appropriate for permanent preservation, And recommended minimum retention periods were given. For patient clinical medical records, it was 8 years after the conclusion of treatment. For children and young people, until their 25th birthday, unless they were 17 at the conclusion of treatment, at which point it was 26, or 8 years after the last entry, or indeed 8 years after death if death occurred before the age of 18. GP records were addressed separately in the circular HSS PCCD 1/2000 entitled Preservation, Retention and Destruction of GP Records. At this point, the inquiry has not been yet found a copy of the document, but if it's found, it will be provided. In 2011, Good Management, Good Records was reviewed and updated, and the 2011 standard now applies to all health and social care records. It sets out minimum retention categories for records as follows. For adults, it's 8 years after the conclusion of their treatment or death. For children, until their 25th birthday, with the provision if they were 17 at the conclusion of treatment, that it should be then retained till their 26th birthday, or 8 years after the last entry, whichever is longer, or 8 years after death, if death occurred before the age of 18. GP records should be retained by the GP until the patient either dies or is no longer a patient of the GP, at which point the records should be sent to the Health and Social Care Board, which should hold most of the GP records, there are some exceptions, for 10 years after the person's death or they've left the country permanently. In 2015, there was a moratorium on destruction of Belfast Health and Social Care Trust records following an instruction from the Historical Institutional Abuse Inquiry, and there's been no destruction of records since 2015. On the 24th of August 2018, following receipt of a letter from this inquiry about retention and destruction of documents, the Permanent Secretary and HSC Chief Executive wrote to the HSC Trust and the Northern Ireland Blood Transfusion Service, amongst others, asking them to take all necessary steps to preserve and catalogue any such material that may be relevant to the inquiry. So that's a broad sketch of the legislative provisions dealing with destruction and retention. So I want to move on to NHS Trust or Health Board policies. The inquiry requested the policies on destruction and retention of medical records from a range of NHS trusts and health boards in Scotland, England, Wales and Northern Ireland. The policies and the frequency of the review of those policies have been provided, and in a moment I will go through a few examples. What most trusts and health boards have not been able to assist with are detailed policies and procedures on retention and destruction for the pre-2000 period. Firstly, in relation to Glasgow, Ian Patterson, Corporate Services Manager of the Greater Glasgow Health Board, has provided two statements to the inquiry about the policies in place for Greater Glasgow and Clyde. For the transcript, the reference is WITN 6911007. He states that NHS GGC followed national guidance on retention and destruction of health/hospital records throughout the period of interest for this inquiry, and has only produced local guidance for administrative/business records. He states that following the creation of NHS trusts in 1993-1994, there was widespread destruction of non-current clinical records, particularly those dating to the 1950s, 1960s and 1970s. In 2002, he notes that the shelving for the archives of Glasgow Royal Infirmary and Gartnavel Royal Hospital collapsed within the archives repository. The affected records were safely recovered from the collapsed shelving with no lasting damage. To the best of my knowledge, he says, there have been no further unforeseen events or incidents that impacted upon records held by NHS GGC. Caroline Leonard, Director of Cancer and Specialist Services at Belfast Health and Social Care Trust, states that there are several archives of microfilm and microfiche records from Trust legacy organisations relating to Belvoir Park Hospital, Musgrave Park Hospital and Purdy's Burn Hospital mental health facility, now known as Knockbracken. In 2018-2019, an exercise was undertaken to locate and compile the medical records for all patients that received infected blood and or blood products and consequently contracted HIV and or hepatitis C. The Head of Information Governance and Management at Guy's and St Thomas's has stated that to his knowledge, no records have been intentionally destroyed. Documents which have been backed up on microfiche are retained and stored off-site. About 200 older haemophilia records are stored in the basement at Guy's Hospital. In Liverpool in 1978, existing records were converted onto microfilm when the Royal Liverpool Hospital opened. Claire Alexander, Director of Quality Governance, has provided the relevant policies from 2004 onwards, but has stated that the Trust is not aware of documents that were in place prior to 2004. Christine Morris from the Lancashire Teaching Hospital NHS Foundation Trust has explained that from 2012 all medical records have been scanned to the electronic paper records system referred to as Evolve. These records are added to by clinicians and are stored on the Lancashire Trust server with a robust backup process in place. Notably here, the Trust's procedural documents, not the medical records, but the procedural records, were themselves subject to a retention period of 10 years, after which the items were destroyed both electronically and in paper form. So that might explain why there's been difficulties in obtaining what the retention policies were at an earlier stage, because they themselves have been subject to retention policies and destroyed. Statements are also available in relation to Birmingham, Derbyshire and Bristol, setting out their policies, and that's set out in the written presentation. The written presentation also sets out some of the evidence that the inquiry has received from clinicians about medical records. So I don't intend to set that out orally because it's already been canvassed, but there is material in the written presentation if people wish to read it.
Yeah.
That takes me to patients' perspective of records under policies. The inquiry has received many statements from infected individuals and their affected family members who were told that medical records have been destroyed in line with NHS Trust Board trusts or boards policies. I'm just going to give a couple of examples. Again, there are many more in the written presentation. In one example, a woman was unsuccessful in obtaining medical records relating to procedures in 1957 and 1976. She was told after extensive inquiries that her records no longer exist. She was assisted by her GP in a process that took many months and proved to be fruitless. She was informed there's no requirement to keep hospital records for more than 10 years. Another example is a statement from a woman whose husband was diagnosed with Hodgkin's lymphoma and died in July 1984, aged 41. She tried to obtain copies of medical records from the Queen Elizabeth Hospital in Gateshead and the Newcastle General Hospital in order to support an application to the Skipton Fund. She was told that the records had been destroyed. She provided to the inquiry a letter from the Newcastle Trust dated the 14th of April 2016, which confirmed that all records held at the Newcastle General Hospital were transferred to the Royal Victoria Infirmary, but they'd been unable to trace the witness's husband as being registered with the hospitals. And it then went on to state that it's likely that the records had been destroyed, saying that under the public records guidelines, adult case notes are required to be retained until 8 years after death and then destroyed. So at that point, it was likely that they had been destroyed. Her application and subsequent appeal to the Skipton Fund were unsuccessful. An affected son, whose mother died in 1981 of chronic active hepatitis, applied for his medical records, and he says this: I received a response from Bart's Trust Archives in which they confirmed that in 2012, Whipps Cross, Newham, Barts and the London hospitals merged to form Bart's Health NHS Trust. They confirmed that as far as patient records were concerned, they did not hold admission, discharge registers, detailed case notes or operations registers. They stated they only received transfers of archival records of Whipps Cross Hospital since 2012 and didn't hold any information on the hospital's records retention practices prior to 2012, at which point they could not assist. As I say, there are then a number of other examples in the written presentation note, and they're there to be read. I want to move on then to the second theme of the presentation, which is environmental destruction. A number of infected individuals and their affected family members have been told that records have been destroyed due to environmental incidents, things like fires, floods, and sewage leaks. There have been 4 challenges in exploring these issues. Firstly, some trusts and health boards do not presently hold records about historic instances where medical records were destroyed. There appears to have been no historic requirement, either nationally or as part of individual trusts or health boards' policies, to record and evidence environmental destruction of medical records. That means that some trusts and health boards have been unable to confirm whether or not the environmental incident that a patient or their family members was told about actually happened. Secondly, even where records of environmental...
By that, do you mean actually happened and those records were part of it? Or do you mean actually happened at all?
I mean whether it actually happened at all. We have health...
So they just didn't know. They don't know now if they had a flood then?
They don't know whether they had a flood on that date.
Or a fire?
Or the fire. The fire is much clearer, but the flood and the sewage leaks are very unclear. And I'll take you through the material we have gathered on that. But certainly in relation to flooding and leaks, there are difficulties that trusts have identified in even telling us whether that did indeed happen. The second difficulty is that even where records of environmental destruction did exist, in several examples, those documents themselves have now been destroyed under retention policies.
Which mean the documents saying there was a flood?
Indeed.
I see.
Thirdly, within the inquiry's investigations, it's apparent that many patients and their family members were told orally about records being destroyed, either in person at hospital or over the phone. And without a written record of those conversations, it's been difficult to investigate, especially where those conversations may have taken place many years ago. Fourthly, where evidence is clear that there was an environmental incident, it's not always then clear which records were caught up in the incident. There may have been a flood or fire, but tracing that through to a person's records being affected has largely not been possible.
So that would mean that all you could show is there wasn't a current record. You had some idea, possibly, that there might have been a fire, though you may not have known exactly when, and it may have been that the records were caught up in the fire, but it may not have been.
Indeed. And with a flood or a sewage leak or a plumbing leak, then it's even unclear. A patient or family member has been told that this happened, but the trust can't confirm or deny whether indeed there was a flood.
And if there was, let's say, a minor flood, it may have destroyed some of the record, but not the rest.
Precisely, sir. And we see that in some trusts and health boards, we will come to it, they were able to restore damaged records. They were sent to specialist locations to be restored successfully. And again, one doesn't know what was restored and what wasn't.
And the records about those?
Perhaps I can come to that in a moment in the presentation. I wouldn't want to say something off the cuff, sir. But they are 4, one might consider quite significant problems when there are environmental incidents. And it's this part of the presentation inevitably then comes with quite significant caveats on what we've been able to achieve. Firstly, looking at floods, the inquiry received a statement from a woman who was given a blood transfusion in 1984 when she gave birth to her first daughter at the Jessops Hospital for Women in Sheffield. Parts of her medical records are missing, And in relation to the hospital records, she was told that the hospital had experienced a flood. The inquiry has obtained a statement from Sandra Carman of the Sheffield Teaching Hospitals NHS Foundation Trust, who's told the inquiry that the Jessup Hospital closed in 2001 and a new Jessup wing was built on a different site. And she says this: despite the thorough searches conducted and the engagement with colleagues across the trust, we've not been able to identify any incident that has caused any irretrievable destruction to medical records by way of fire or flood. In relation to the possibility of a flood at Guy's and St Thomas's in the late 1990s, the statement from that trust confirms: I'm aware of a flood in 1998-1999. I've seen reference to destroyed in flood in comments in the previous patient administration system, although I do not have any further information in relation to this. I further understand that there was a leak or flood in 2008 in an old porter cabin where some inpatient observation charts were kept. I understand that there were in the region of 150 boxes of records which were affected by the leak/flood and which were then consequently destroyed. This incident was investigated as part of a serious untoward incident investigation. I've not yet been able to find the resulting report. To my knowledge, neither of these incidents relate to haemophilia records, but of course, those records may relate to those who received a blood transfusion or other records such as hepatology records. A man with mild haemophilia A who was treated at the Manchester Royal Infirmary during the 1960s to 1980s was diagnosed with hepatitis C in 2005. He applied for his medical records shortly after his diagnosis. He was told that most of his records had been destroyed and that they'd experienced a flood in the past. He says, I also applied to Lancashire and South Cumbria Agency for my medical records and was informed they'd also been destroyed. A statement from the Manchester University NHS Foundation Trust has been unable to confirm the existence of a flood, saying this: that despite inquiries made with the Manchester Royal Infirmary's senior management team, clinical governance team, estates and facilities team, subject access request team and medical records team, we have been unable to verify whether such an event occurred. This is due to the passage of time since the alleged event and the present day. One long-standing staff member could recall a series of floods at the MRI that affected the medical records library, which used to be in the basement. However, due to the passage of time, this member of staff cannot recall exactly when the floods occurred, but does believe they were around the time in question in the mid-1980s. The statement also confirms that no records referencing the flood exist because of trust policy on retention, which means that those policy records have been destroyed. In relation to Belfast, a statement has been received confirming that in June 2012 there was a flood at one of the Musgrave Park Hospital libraries, which was located in the basement of the Withers Orthopaedic Centre. The writer states that a small number of records were damaged due to the flooding, and they were subsequently sent to Harwell Restoration in Oxford and successfully restored. In October 2014, there was more extensive flooding at the site, but no records were damaged. Due to those flooding risks, the libraries have been moved to another area.
Yes.
Similarly, in relation to the Royal Belfast Hospital for Sick Children, a contractor in 2016 hit a plumbing pipe, and the leak caused substantial damage to offices and medical records were water damaged. But again, in that context, the records were sent to a specialist restoration company. And in September 2020, there was a flood at an off-site record storage site. One of the records in a box was water damaged and was successfully restored. An infected individual was informed of a flood destroying medical records at St Mary's Hospital, Portsmouth. That trust has provided a statement to the inquiry stating that the trust were unable to confirm or deny the existence of a flood. Records of such incidents prior to 2002 were completed on paper and have been destroyed in line with retention policies. Staff members who worked in the hospital from 1987 to 1997 do not recall a flood. Moving then to fire. Firstly, turning to the Lancashire Teaching Hospital NHS Foundation Trust, Christine Morris, an Associate Director, has confirmed that there was a fire at the site of Sharrow Green Hospital on the 24th of July 2005. The building was scheduled for demolition and had been closed as a functioning hospital, but it was being used to house medical records. There was an incident of arson, and the damage caused is really very extensive. The trust sent photographs to the inquiry of the damage. Approximately 87% of medical records held at the Sharrow Green Hospital were lost in the fire. Paper medical records were not backed up in 2005, and as such, records destroyed during the fire are not available, although a list of the record numbers is available. The inquiry's also received a statement from a man who was infected with hepatitis B and hepatitis C, who's told the inquiry that he tried to obtain his records from the Birmingham Children's Hospital in 1995 and again in 1997. On both occasions, he was told there'd been a fire at the Birmingham Children's Hospital and his medical records were lost or destroyed. The University Hospitals of Birmingham Foundation Trust have provided a statement and said that there is no knowledge or awareness of any instances where records were disturbed, misplaced or destroyed because of an incident. In relation to King's College Hospital, a woman who was infected with hepatitis C after receiving a blood transfusion on the day she was born in 1974, then attended the adult liver clinic who wanted to look back at her childhood records. She was told then that they may have been destroyed in a fire at the hospital some years earlier. There is then further statements from witnesses and from other hospitals in relation to Derbyshire Royal Infirmary. An affected brother-in-law attempted to obtain the medical records of a man who had died in 1996 after being co-infected with HIV, hepatitis C and hepatitis B. He says this: "I've received several versions of events. For example, I was informed they were destroyed in 1995. But I don't believe this to be true, as it was the year before the man died. I've asked for proof of destruction, which I've never received. I've asked where they were sent to, and then I was told there was a fire which destroyed them, that they've now ceased to communicate with me." And he contrasts that with the provision from Leicester. In a statement from the University of Derby and Burton NHS Foundation Trust, the Trust states they've been unable to locate the nature or causes of a fire or any other event at the Trust which caused the destruction of records in 1995. The Trust has not been able to locate any information in relation to damaged medical records in relation to an incident around 1995. And we then have further examples in relation to Liverpool. And so I just want to put up the paragraph from that statement at WITN 7166001, because I think it does deal with environmental issues, but it also deals with some of the other challenges. Page 2, please. And in relation to the Liverpool Trust, it says this: "Prior to the opening of the Royal Liverpool Hospital, I understand that the closing hospitals in Liverpool were allocated a new RLH number to each convert their records to the same numbering system. This resulted in some patients having more than one number in the RLH. During this time, it's understood that there was some damage to roofs of some of the old buildings, including water and fire damage, which resulted in paper records being officially written off because they were unreadable / unusable. There is a potential for some of those then current records, which began before 1980, having been destroyed. The RLH opened in 1978. So you might also want to simply note the next paragraph. The non-current records at the opening of the RLB, which needed to be retained, were microfilmed. And if a patient presented to the new RLH, their microfilmed records were copied under their old case note number and another volume of records was commenced. Once discharged, the record was then microfilmed and then filed behind the first volume microfilm, then second volume, etc. The Royal and Broad Green Hospitals amalgamated in 1995, and it's understood that the same process was followed. A number of paper records held in an attic at Broad Green that were over 25 years old were sent for destruction. So there's another example of records being destroyed in water and fire damage, as well as added complications of microfilmed records and different case numbers. In the written presentation, there are further examples dealing with Newcastle and Leicester. Moving on then to sewage leaks. The inquiries received a statement from a widower whose wife contracted HIV. She'd received blood transfusions at the St Mary's Hospital in Paddington in 84 and 85 during treatment for ulcerative colitis and septicemia. He obtained her records from treatment in Scotland, and in 2003 a clinician found some scarce documents on microfiche, including information about her treatment in 84 and 85 and that she had received units of red cells and FFP. The National Blood Service attempted to trace all the units in her file, but they concluded that the donation numbers on the microfiche were transcription errors because the donations linked to different hospitals and different times. 2007, he tried to access the records and he was told that her records had been destroyed in a sewage leak. His MP then also was engaged in it, and he expresses significant surprise that the records had not been retained, because he was then told that they'd actually been routinely destroyed. A statement's been obtained from Imperial College Healthcare NHS Trust about whether there was a sewage leak or other event, and the statement says this: attempts have been made to locate information regarding this, and whilst it appears that a flood may have occurred, corporate records are only retained for 7 to 10 years, and unfortunately, therefore, no information is available. A colleague who's worked in the Health Records Department for some considerable years recollects a flood occurring and that the paper records which were damaged were sent to a document recovery company, repaired and returned. Unfortunately, no documents exist relating to this. They note that if such an incident occurred now, it would be reported through Datix and the risk management reporting systems. So that takes me to my third theme, difficulties in obtaining medical records. And there are effectively 4 subparts: closed hospitals, requests for records being ignored, delays in obtaining records, and issues surrounding the quality of medical records and missing parts of records. From a number of witness statements, we've identified a theme that individuals have been unable to access medical records because of the closure of hospitals. This is particularly common for women who received transfusions at specialist maternity hospitals or units, which have since closed down. Many of these witnesses question why there was no national or local policy or procedure in place that prevented destruction of their records in such circumstances. Others ask why their medical records were destroyed without their consent or prior notification. And there is some examples in the written presentation, which I won't go through. Another theme from a small number of statements is of requests for medical records being ignored. An affected son whose late mother was infected with hepatitis C has told the inquiry that he hit a brick wall in relation to accessing his mother's medical records. He set out the number of times he sought access to the records, and the response from the Trust is described by the witness as vague and didn't confirm whether records had been destroyed. The letter from the Trust that he's critical of says this: Primary Care Support England holds the GP records for deceased patients for a period of 10 years after death. Our records show the above named passed away over 10 years ago. Therefore, in accordance with NHS policy, these medical records are no longer available. A refund will be issued for your payment. The witness then sent another letter asking to confirm whether there were any records, and he then did receive confirmation that the records had been destroyed under the hospital's retention policy. A number of statements also identify a delay in obtaining records. Although records might eventually have been provided, this cohort of individuals found that they had to make formal written complaints or approach their MPs in order to obtain some or all of the missing records. Witnesses have described the process as being extremely difficult, of the process being laborious. One witness instructed solicitors to assist him with obtaining his father's records. The hospital stated they were unable to trace his father. The witness then asked for his MP to be involved, who wrote to the chief executive of the hospital. This in turn triggered a response from the trust that they did identify his father's records, but that the records had by then been destroyed. Other witness statements identify evidence that individuals have been told that their records had been destroyed, but then, subsequently, records have been found. A man with haemophilia who commenced at Factor VIII treatment in 1978 was treated at Manchester Royal Infirmary and at Trelaws. In 2017, he obtained his medical records from his solicitors. He'd previously been told that his records had been destroyed approximately 8 years after his last attendance at Manchester Royal Infirmary. A woman was infected with hepatitis C after receiving a blood transfusion at the Poole General Hospital in 1988. She attempted to obtain her medical records in May and June 2015, but was told her records were unavailable. She asked whether her records had been destroyed or whether they'd been transferred to another medium, but states she didn't receive answers to those questions. On the second occasion, she was sent maternity records in relation to her youngest child. She then applied to her GP practice for her medical records, and she received a telephone call from the receptionist that some of her records had been located, but records covering 1988 could not be found. She reports that the records, she was told, had been found at the back of a cupboard in the basement. Infected individuals and their affected family members have also raised concerns about inaccuracy in their medical records. Broadly, these fall into two main categories: inconsistency between what is recorded in the notes and the information that was given or not given to a patient, and inaccurate information being recorded in the records. The available evidence suggests that patients have struggled to get inaccurate information altered in their medical records. Some witnesses have highlighted to the inquiry that upon reviewing their medical records, those records contain different information to what individuals have been told or not told orally by treating clinicians. To date, the inquiry has heard a significant amount of evidence from infected individuals and their affected family members about those sorts of communication issues, and I'm not going to repeat that today. There are further examples provided in the written presentation. Similarly, in relation to inaccuracy of medical records, the inquiry has heard already a significant amount of evidence on that point. There are further examples in the written presentation where things are in the records which are, according to the witnesses, simply wrong. Similarly, UK HCDO records, the inquiry has heard a significant amount of evidence about errors and omissions in those records. We then come to missing records. So I note the time. I don't know whether it would make sense to just pause there for our afternoon break. I don't think I'm going to be very much longer, but probably about another 15 minutes or 20 minutes.
In that case, take a break.
Thank you.
Come back at 3:45 and see how we go.
Thank you, sir.
3:45.